Welcome to this explainer. Okay, today we're decoding Chapter 2, Unit 1 of the Indian Contract Act of 1872. I know. Reading the law can honestly feel like trying to decipher some ancient lost language, especially when you're knee-deep in ICAI exam prep and feeling totally overwhelmed. But hey, don't sweat it. I've got you covered. We're going to take all that dense legal jargon and basically turn it into simple visual math. You'll have it memorized in no time. So let's dive right in. All right, here's our exact game plan for today to get you fully prepped for the ICI pattern. We'll start with what a contract actually is, compare it directly with an agreement, map out the absolute essentials of a valid contract, break down the different types, and then wrap it all up with offer and acceptance. Simple, right? Let's go. Section 1. What is a contract? Let's start with the ultimate golden rule, by reverse engineering a valid contract from the ground up. You see, every single business transaction, every legal relationship begins with a spark. And that spark, it's just a simple offer. Someone proposing something to someone else. Then, the other person hears that offer, thinks it over, and gives their clear acceptance. They basically say, yep, I'm in. I agree to those exact terms. And when you add an offer and an acceptance together, boom, you get an agreement. It's a super simple equation. One person promises something, the other accepts, and they've got mutual promises acting as consideration for each other. But an agreement all by itself, it isn't quite enough to get you to a full-blown contract. Now, here's where the real legal magic happens. According to Section 2H of the Indian Contract Act, an agreement enforceable by law is a contract. So our final formula is just contract equals agreement plus enforceability. Because if the law won't actually back you up when things go south, well, you just have an agreement, not a contract. Section 2. Agreement versus contract. So you might be wondering, what exactly is the difference between the two? It's a fundamental concept you absolutely need to master. Let's look at Section 2E of the Act. It tells us that every promise and every set of promises forming the consideration for each other is an agreement. It's essentially just a mutual exchange of promises. You promise to come over for a dinner party, and I promise to cook. That right there, that's an agreement. Now, if you remember just one thing for your exam today, make it this comparison. An agreement has a much wider scope. It includes casual, everyday social promises, like that dinner party we just talked about. A contract, on the other hand, has a totally narrow scope. It's strict legal business. It necessarily creates a legal obligation and grants actual rights. If you break a contract, you're facing legal consequences. But if you just ghost my dinner party, I'll be annoyed, but I can't exactly drag you to court over it. Section 3. Essentials of valid contracts. All right, let's move on to the actual ingredients required to make an agreement legally enforceable. So, the crucial thing here is knowing exactly what makes an agreement hold up in front of a judge. Think of Section 10 of the Act as laying out your essential baking ingredients. You must have an offer and acceptance. You need free consent, which just means nobody's being pressured or tricked into signing. You need competency or capacity of the parties, basically ensuring they're of legal age and of sound mind, and you absolutely need lawful consideration, a lawful object, and the agreement cannot be expressly declared void by the law. But wait, there's more. The sources point out something pretty fascinating. There are actually essential ingredients not explicitly listed in Section 10, but the courts consider them absolutely necessary anyway. For instance, you gotta have two distinct parties. You literally cannot make a legally binding contract with yourself. There must be a clear intention to create a legal relationship. The terms have to have certainty of meaning, and this is a big one. The performance of the contract must actually be possible. Like if I offer to discover a brand new planet for you by tomorrow morning, well, that's literally impossible, so it can never be a valid contract. Section 4. Types of contracts. Because contracts definitely aren't one size fits all. Let's organize the chaos and look at the different flavors they come in. This framework beautifully illustrates the entire landscape of contracts. We classify them on three bases: validity, formation, and performance. Under validity, we've got valid, void, voidable, illegal, and unenforceable contracts. For formation, a contract can be express, implied, quasi, or an e-contract. And based on performance, it can be executed, meaning the whole thing is already done and dusted, or executory, meaning it's still waiting to be performed. Seriously, this framework is your ultimate screenshot-worthy cheat sheet for your studies. I really want you to pay special attention to this absolute ICI favorite, the difference between a void contract and a voidable one. According to Section 2J, a void contract is one that simply ceases to be enforceable by law. It is completely dead in the water, nothing you can do.
But avoidable contract, defined in Section 2I, is a bit trickier. It is enforceable at the option of one or more parties, but not the other. This usually happens when one party's consent wasn't totally free, which basically gives them the unique power to either cancel the contract entirely or just let it proceed. They hold all the cards.
Section 5. Offer and acceptance. Finally, let's zoom in on the specific sparks that ignite this whole legal machine. An offer, which the Act formally calls a proposal, is strictly defined in Section 2A. It happens when one person signifies to another their willingness to do or to abstain from doing something, specifically to obtain the assent of that other person. Basically, you're putting out a signal. You're saying you're willing to do something just to see if the other person agrees to your exact terms.
But, there are strict legal rules to make an offer actually valid. The crucial point here is that an offer cannot be vague. It has to be certain and definite. The study material gives a perfect example. If you offer to sell someone 100 quintals of oil, you must specify exactly what kind of oil. Olive oil? Motor oil? Without that certainty, it's just not a valid offer. Also, you absolutely must communicate it to the offeree. You can't just think about an offer in your head. The other person actually has to know about it to be able to accept it.
Which naturally brings us to acceptance, defined in Section 2B. Acceptance happens the exact moment the person to whom the proposal is made signifies their assent, their clear, undeniable yes to that specific proposal. And once accepted, that proposal instantly transforms into a promise.
And please remember this massive legal trap for your exams. Acceptance must be an absolute, unqualified mirror image of the offer. If you try to change even one tiny term, that's not acceptance anymore. That is a counteroffer. It also must be communicated in the prescribed mode, and importantly, mere silence can never, ever equal acceptance. You cannot legally say, hey, if I don't hear from you by Friday, I'll just assume you accept. No way. The law requires a definitive signal.
Which brings us right back to our ultimate anchor rule, the one that ties this entire unit together beautifully. All contracts are agreements, but all agreements are not contracts. Why? Because every single contract needs that foundational agreement to exist, but an agreement without legal enforceability is just, well, an agreement. So I'm leaving you with this thought to really solidify your understanding today. Based on our visual math and everything we just went through, could a contract ever possibly exist if you completely skipped the agreement phase altogether? Ponder that equation, keep reviewing these core principles, and you are absolutely going to crush your exams. Thanks for hanging out with me for this explainer.